Part 3 is entitled Types of Criminal Courts. The first classification scheme lists the courts as the Supreme Court, the Court of Appeal, federal, state, and ACT high courts are treated together, and finally the lower courts. Let's begin with the Supreme Court. Established by Section 230 of the 1999 Constitution as amended, constituted by its head the Chief Justice of Nigeria and such number of justices as may be prescribed by an act of the National Assembly. This is Nigeria's highest court and has been so since 1963, when Nigeria made a clean break from the British judicial system. Until its establishment, the highest court in Nigeria was the Federal Supreme Court. The now abolished Federal Supreme Court was not a final arbiter, since appeals from it went to the Judicial Committee of the Privy Council. Our next court is the Court of Appeal. Established by Section 237, subsection 1 of the 1999 Constitution as amended, initially by the Court of Appeal Decree, now Act No. 43 of 1976, and the Constitution Amendment Decree, now Act No. 42 of 1976. It is constituted by its head, the President of the Court of Appeal, and a number of other justices, not less than 49, provided that not less than 3 shall be learned in Islamic personal law, and not less than 3 shall be learned in customary law. This is the second highest court of the land, and also serves as an intermediate court between the Supreme Court on the one hand and the High Court on the other hand. The next set of courts is the federal, state, and ACT high courts. The reason for considering these courts together is that they have equivalent powers and ranking. The federal high courts was established by Section 249 of the 1999 Constitution as amended. It is formerly known as the Federal Revenue Court, which was established in 1973, then renamed the Federal High Court in the 1999 Constitution. The State High Court is established by Section 270, subsection 1 of the 1999 Constitution as amended. This and the various High Court laws of those states control its operation. The High Court of the ACT is established by Section 255, subsection 1 of the 1999 Constitution as amended. By virtue of Section 252, subsection 1 of the 1999 Constitution as amended, the Federal High Court is basically equivalent to the High Court of a state. The Federal High Court is constituted by its head, the Chief Judge of the Federal High Court, plus such number of judges as the National Assembly prescribed in its enabling act from time to time. While state high courts are constituted by its head, a chief judge, plus such number of judges as the State House of Assembly may prescribe in its enabling law from time to time. The High Court of the FCT is constituted by its head, a chief judge, plus such number of judges as the National Assembly prescribes in its enabling law from time to time. Let's take a look at the lower courts. These include area courts, customary courts, magistrate courts, and Sharia courts. Magistrate courts are established by the magistrate court laws of their respective states, while area and Sharia courts were established by the Area Court Edict of 1967. In some northern states, these are known as Sharia courts. In other northern states, these are known as area courts. Customary courts are established by the respective state laws as well. With that, we are done with the first classification scheme, that is based on type, the naming of the courts. We propose another classification scheme, and that is courts with original general criminal jurisdiction, courts with original special criminal jurisdiction, courts with appellate criminal jurisdiction, courts with worldwide criminal jurisdiction. Let's take them one by one. Courts with original general criminal jurisdiction. These are courts in which one can commence criminal proceedings at first instance, courts empowered to hear all cases that are not specifically reserved for courts of special jurisdiction at first instance, courts empowered to conduct trial into a case involving parties without discrimination or limitation, and over a wide range of subject matters. These include magistrate courts in the north, magistrate courts in the south, high courts in the north, and high courts in the south. We also have courts with original special criminal jurisdiction. These are courts in which a particular class of individuals can be tried for criminal misdeeds at first instance. Courts in which a particular class of criminal omissions or commissions, actual or suspected, can be tried at first instance. Courts empowered to conduct a hearing of a case involving a controlled list of potential parties and or over a limited or specific range of subject matters. These include area or Sharia courts in the north, customary courts in the south, federal high court when trying criminal matters, juvenile courts which tries young persons, court-martials which try members of the forces, coroner's court which conducts inquests into the causes of death, and any other tribunals. Let's take one of the types, area courts and Sharia courts. By virtue of Section 24 of the Area Court Edict of 1967, it restricts area and Sharia courts from trying offences punishable by death. That's subject matter jurisdiction. The jurisdiction over offenders at the area and Sharia court is limited to any person whose parents were members of any tribes indigenous to some parts of Africa or their descendants, any person, any of whose parents was a member of a tribe indigenous to Africa, and a person who, while not falling among the two categories above, consents to be tried by the court. Subject matter jurisdiction is as conferred by warrant or by law. The juvenile court's jurisdiction includes all young persons aged 14 and above and under 18, except the youth is charged jointly with an adult, in which case the juvenile court is robbed of its jurisdiction, or the youth is charged with culpable homicide. We'll now be moving on to the Federal High Court. Sections 251, subsection 1, 2, and 3 of the 1999 Constitution as amended lists the extent and limits of the subject matter jurisdiction of the Federal High Court. This legislation needs to be considered side by side with the following cases to grasp the extent and limits of the jurisdiction of the Federal High Court, as this is a favorite for examiners. Abbas vs. Commissioner of Police is a 1988 case. Alhaji Mandara vs. Attorney General of the Federation, 1984 case. Rolling Motors Limited vs. Wema Bank PLC, and in 1983 case. Easy vs. the Federal Republic of Nigeria in 1987 case. Savannah Bank vs. Pan Atlantic Shipping and Transport Agencies Limited, which is in 1987 case. We are now done with the Federal High Court. We will now be considering court-martials. This court is endowed with two types of jurisdiction. Subject matter jurisdiction is as provided for in sections 45 to 103 of the Armed Forces Act and broadly includes military and civil offenses. Offender jurisdiction is as provided for in section 130 of the Armed Forces Act. By offender jurisdiction is meant persons subject to service law. But see also Olatunji vs. the State, a 2003 case. This is another examiner favorite. And the sort of questions to expect include the types of court-martial, the composition of the various types, the roles of each official in the various court-martials, the rules governing procedure, who can be appointed a member, who can head and who cannot head a court-martial, the quorum that needs to be formed, conditions to be met before an officer can be tried, who can convene the two types of court-martial, whether the power to convene can be delegated, who is subject to its jurisdiction and who is not, when can it impose the death sentence, the difference between the two types of court-martial, triable offenses, can an ordinary court try a case already tried by a court-martial, and vice versa? On the screen you can see a picture of the Federal High Court. Another picture of a court-martial. Now let us move on to the next classification subtype, courts with appellate criminal jurisdiction. These are courts which can hear criminal cases on appeal, courts empowered to hear criminal cases following or after their determination by either a court with original general criminal jurisdiction or a court with original special criminal jurisdiction, or both. Courts empowered to review a trial court's proceedings for error. These include high courts in the north and high courts in the south, the high court of the FCT, the Court of Appeal, and the Supreme Court. High courts in the north. These exercise appellate jurisdiction with respect to all appeals from magistrate courts and upper area or Sharia courts. Let's see section 272 sub 2 of the 1999 Constitution as amended, but subject to section 251 of the 1999 Constitution as amended. High courts in the south, which exercise appellate jurisdiction with respect to all appeals from magistrate courts. See section 272 sub 2 of the 1999 Constitution as amended, which is subject to section 251 of the 1999 Constitution as amended. High Court of the FCT. This exercises appellate jurisdiction with respect to all appeals from magistrate courts. See section 257 subsection 2 of the 1999 Constitution as amended, but subject to section 251 of the 1999 Constitution as amended. We also have the Court of Appeal, which has no original criminal jurisdiction, but only appellate criminal jurisdiction with respect to decisions of the following: the Federal High Court, the FCT High Court, State High Courts, court-martials, any other tribunals established by the National Assembly. Please see section 240 of the 1999 Constitution as amended. We also have the Supreme Court, which has no original criminal jurisdiction, but only appellate criminal jurisdiction with respect to the decisions of the Court of Appeal, the only limitation being the powers of the President in the case of the Federation, or the Governor in the case of a state, to grant prerogative of mercy as contained in Section 235 of the Indian Constitution as amended, and Section 233 of the 1999 Constitution as amended. On the screen is a picture of the Court of Appeal, which we have just considered has appellate criminal jurisdiction. This is followed by a picture of the Supreme Court, which we have also discussed has appellate criminal jurisdiction in respect of decisions of the Court of Appeal. Our last type of court is the International Criminal Court. This court has jurisdiction over individuals and not states. It tries to hold such persons accountable for the most serious crimes of concern to the international community as a whole, namely the crime of genocide, war crimes, crimes against humanity, and the crime of aggression. This is the end of the third part of this course.